Hey everybody, it's Christine here with Help Solve the Case. We are talking about Scott Peterson in California and the petition for habeas relief, okay? From what I understand, there is another one besides this that is working its way through the system, something regarding the jury tampering or something. And this one was new evidence, and it's huge. It's 659 pages. There's another video which I can link to where I kind of went over what the Innocence Project discussed in their response to the initial ruling. This petition was denied, and they're going to escalate it. And so I went through that, and I have this document. It's huge, like I said, and I've had some requests to go through it. So I thought I had a little time this morning, and I thought I would take an initial look at it. We could kind of go over it, and then you all, which I appreciate you being here, could let me know if you want to see more of this. We could walk through it. I try to give you guys the analogies, my police perspective, my criminal justice. I've been in the legal system for a long time, and just give you guys my perspective. And so I thought we'll try it, okay? So here goes. Page 1 of 659. And this was filed in August, okay, of 2025. So they're talking about, this was filed by the attorneys for Scott Peterson. You're probably aware, if you're watching this video, that he was convicted, right, of murdering his wife and child. And they are petitioning habeas. I'm not an attorney. Habeas is a method to petition to a part of what they call PCR, or post-conviction relief. And he is looking through, and I think it's telling, interesting that the Innocence Project took it on. A lot of people ask for the Innocence Project and they don't get it, okay? So I think that's interesting. So they are saying they're going to put this language in here that he's unconstitutionally restrained of his liberty, right? Which we're all entitled to that, life, liberty, and the pursuit of what we want to do, right? Freedom, justice, all that. So they're saying that he's being unconstitutionally restrained. And it looks like he's in Mule Creek State Prison. And they are filing this because they're claiming that he was wrongfully convicted when the jury relied on false evidence. And this is, let me make this clear. This is his attorneys stating this, his attorney's facts, his attorney's allegation to the judge, that the jury relied on false evidence, false scientific evidence, which violated his constitutional and statutory rights, because you get due process in a fair trial. All right. It says the scientific new evidence was not available at the time of trial, and it not only supports his claim of innocence, it undermines the prosecution's entire circumstantial case against him. And I think those words to me carry a lot of weight. So they're saying that it supports innocence, like complete innocence, and his the entire circumstantial case. Okay, so when they say circumstantial, they're saying circumstances convicted him, in their opinion, right? That the case is circumstantial. All right, and the claims of innocence. It's not just, we've got a procedural error and we want it fixed. Okay, that's two things that they're saying there. It says that his constitutional right to due process and a fair trial were violated. And this is another, like they're throwing them out there. When the prosecution intentionally and suppressed and destroyed critical physical exculpatory evidence. Exculpatory means it would show that he wasn't the person. You have inculpatory and exculpatory. So they're going through some stuff here that they feel that he's made a prima facie case, which means on its face, the facts are, I'm not the legal jurisprudence expert here, but it's on its face that he should be entitled to it, right? And here's why. So it says, if true, these facts, if the facts that the relief states, which they're doing, this is what they're doing, they entitle him to relief. And they cite some citations here from the court. And they want an order to show cause. Okay. And that if the petitioner's factual allegations are taken as true, would entitle him to relief. Okay. So legal mumbo jumbo about they're saying we deserve relief, and this is why. So he says they're claims based on newly discovered evidence, they're not procedurally barred, and they're supported by factual allegations and evidence which, if taken as true, entitle him to relief, and because of that, they want the writ and issue an order showing cause. Okay? So this is all of it I talked about, okay? Like, do you want me to go through all of this? Maybe there's parts of it that you guys could pick and choose. So we've got here going to go through the history of the case, okay, the procedures. They're maybe going to touch on some due process issues, not sure. Talking about juror misconduct, the post-conviction, the Los Angeles Innocence Project post-conviction investigation. They're going to talk about their factual overview, what they believe to be the facts. The police investigation, I believe that's Modesto Police Department. Okay. They're going to talk about his demeanor, his cooperation. They're going to talk about a burglary. Is it Modesto or is it Medina? Not sure. I'm not sure exactly what city he lived in, but obviously it's an M. Okay. They're going to talk about credible witnesses. They're going to talk about lead investigator did not investigate something. About MPD broadcasting his location, searches, his cooperation, it appears. Some search warrants where nothing was found. Scent items. Detective, okay, so maybe Medina is the people that owned that house. I'm not sure. Detective Gregan did not investigate it as the burglary as part of the missing person investigation. The press releases consistently contain misinformation to pressure him to confess. That's a good statement there. James Romano, base searches. They did not search the waters around the Albany bulb. Connor and Lacey were found 1 mile apart. Target bag and debris. Medical examiner. They couldn't determine the cause and manner of death. Multiple warrants. Found no evidence pointing to guilt. The home in Modesto had become unlivable. Not planning to flee Mexico. Prosecution destroyed exculpatory physical evidence. Just different things about evidence. Then they're going to talk about the scope of claims and the evidentiary bases, meaning it's not procedurally barred because they have to meet certain elements to get this granted. Okay, the order to show cause, they got to meet certain standards and processes to get it done. So they're talking about relief, and then they're talking about the claims for relief here. They're talking about claim 1. He was denied his right to due process when the prosecution presented false scientific evidence by Dr. Devore regarding Connor's date of death, and that new evidence undermines the prosecution's entire theory of the case and exonerates the petitioner. Claim 2. Petitioner was denied his right to due process when the prosecution presented false and unreliable evidence by Dr. Chang that Connor's body was anchored in the bay at the precise location where petitioner fished. New scientific evidence undermines the prosecution's entire theory of the case and exonerates the petitioner. Claim 3, that he was denied his right to due process when the prosecution presented false evidence by the scent dog handler, Eloise Anderson, who testified her dog picked up, in quotes, Lacey's scent at the Berkeley Marina. New evidence in claims 1 and 2, up here, exposed the falsity of her testimony and undermines the prosecution's theory of the case. Claim 4. Let's see how many we got here. Okay. Claim 4. New evidence exonerates petitioner, shows that Lacey confronted one or more of the Medina burglars on December 24th and that the petitioner was denied his right to due process when the jury relied on false evidence and false argument that the Medina burglary did not happen until December 26th. Claim 5. New evidence. Petitioner was denied his right to due process when detectives Grogan and Burkini falsely testified there were no credible witness sightings of Lacey and that petitioner was the last person to see her alive. Claim 6. New evidence by forensic document examiner Dr. Linton Mohammed shows that petitioner did not, as the jury was told, secretly buy a fishing boat without telling Lacey as part of a premeditated plan to kill her and secretly dispose of her body in the bay. Claim 7. Reversal is required because petitioner was denied his right to due process when the prosecution intentionally and in bad faith destroyed MPD's January 2nd videotaped interviews with Medina burglars Todd and Pierce and destroyed the Medina safe in violation of Trombetta Youngblood. And those are case, more than likely, name sounds familiar, case citations, adopting standards or used in challenges. Not sure that they're very familiar names to me. We could go into those in more detail. Claim 8. Reversal is required because petitioner was denied his right to due process when the prosecution intentionally and in bad faith destroyed the Aponte tapes and reports which had exculpatory value in violation of Trombetta and Youngblood. Again, case decisions. Claim 9. Reversal is required because petitioner was denied his right to due process when the prosecution intentionally and in bad faith destroyed the Croton watch MPD collected from the pawn shop and related MPD investigation reports, which had exculpatory value in violation of Trombetta Youngblood. Claim 10. Reversal is required because petitioner was denied his right to due process when the prosecution intentionally in bad faith failed to collect exculpatory evidence by systematically ignoring eyewitnesses who reported seeing Lacey alive and walking the dog in the neighborhood and park in violation of Trombetta Youngblood. Claim 11. Petitioner is entitled to relief because he was prejudiced by the prosecution's suppression of evidence favorable to the defense in violation of his right to due process under Brady and its progeny. So they're not only claiming Trombetta Youngblood, but they're claiming Brady. They're talking about the Todd and Pierce interviews, the safe, the Croton watch, something about Detective Stowe's admission, interviews, Susan and Rudy Medina, a van fire, James Romano reports, Lacey knew about the boat purchase, and Lieutenant Xavier Aponte report. Claim 12. Petitioner was denied his right to due process when the prosecution presented false arguments to the jury. New evidence undermines the prosecution's entire circumstantial case against petitioner and lays bare the falsity of the prosecution's entire argument presented at trial. In that, petitioner did not use the boat cover to conceal a body, and Lacey's body was not found in the clothing she was wearing the evening. Interesting. Her body was not found in the clothing she was wearing the evening of December 24th. So I'm not sure what's going on between two dates there. Claim 13, cumulative error. Maybe it all adds up. And then 14, the actual innocence, which I said is separate in itself, right? They want a determination. And then it says memorandum of points and authorities. They're going to go through the legalese. Man, all these things. This goes on and on. Okay. It's a biggie. Petitioner's conviction must be overturned because his right to due process was violated when they suppressed and destroyed evidence favorable to him in violation of Brady and Trombetta, Youngblood. They're going to talk about those. So that might be interesting in the 500s. So much here. We could go for months. Okay, now these are some of the cases that they're going to be citing. Here's Arizona versus Youngblood. So it's great. I live in Arizona, right? We got Miranda, we got Youngblood. We got Brady versus Maryland. That's not, it's not Arizona. Where's the other one? What did he say? Youngblood and Trombetta. So you might want to familiarize yourself with these: Trombetta, Brady, and Youngblood, because they're going to rely on those. A lot. And what they're doing when they have these other cases there's been decisions that other judges or other judicial bodies have made what they call precedent. Okay, and so you kind of want to say, well, if you did it here, if it was okay here, or it had this meaning here, then it has to apply over here. Okay? I guess that's the easy way to say it. All these codes, exhibits. Okay, they got all these exhibits. All right. On April 8th, 2003, Scott Peterson was arrested and charged with the capital murder of his wife Lacey and their unborn son Connor. On March 16th, 2005, he was sentenced to death pursuant to a judgment rendered in San Mateo County Superior Court after a jury found him guilty of first-degree special circumstance murder of his wife Lacey Peterson and second-degree murder of their unborn son Connor. He has petitioner, they're petitioning for Scott, has at all times prior to trial and since his conviction maintained his innocence. So there's no confession, nothing. On August 24th, 2020, the California Supreme Court vacated petitioner's death sentence on direct appeal, and on December 8th, 2021, he was resentenced to life without the possibility of parole. So that's interesting. I don't know what the basis for that was, if that was part of this, or if it was something else, like if it's something that they're including here, or if that is something different, or if this is because of the jury, this second habeas. So it says on October 14, 20, again, I'm not real familiar with his case. I heard it in the news. I work my own cases on a daily basis, and I come in to look at these things when I find an interesting point of law, when I find it might be applicable to a case I'm currently working, or when you guys ask me to take a look at them. Sometimes attorneys call me in to take a look at cases, right? So So I'm not exactly sure what was going on there, but we heard a little bit about that in the press release. So, because I'm hitting here, it says August 21st, they vacated it, which was before October 2020. So I'm thinking they're different. You guys can comment, let me know. And we could go back and look at that if you're interested. But okay, we got 659 pages. We're on page 23. Okay. So it says the case was remanded to the San Mateo County Superior Court for briefing, evidentiary hearing they had, which took place February 25th, 28th, March, blah, blah, blah. And on December 20th, 2022, the Superior Court denied petitioner's jury misconduct claim. So that can't have anything to do with August 2020. Okay. In April 2023, petitioner filed a pro se petition in the Court of Appeal, asserting his innocence, raising claims of constitutional and statutory error, including a claim that the Superior Court erred in denying his juror misconduct claim, among other claims. In July 2023, the Los Angeles Innocence Project agreed to review the evidence presented against him at trial and investigate new evidence that has since come to light. So, in 2023, he filed a pro se petition, which means he's representing himself. Okay, April 2023. And then it sounds like the Innocence Project came on his case in July 2023. Not sure. It's kind of what it sounds like. Okay. So they came on in July 2023 is what we think. In 2024, as part of its investigation, I'm just going to call it, we know it's the LA Innocence Project. I'm going to call it Innocence Project rather than say LAPE. I don't know. Litigated motions means they argued, they went before the court. Motions for post-conviction discovery and DNA testing pursuant to California statutes. And their investigation uncovered new evidence supporting petitioner's claim of innocence as set forth in his verified amended petition for writ of habeas corpus, including new scientific evidence that was not available at the time, new exculpatory evidence, and newly discovered evidence of Brady violations, including Trombetta Youngblood claims, all of which support petitioner's claim of innocence and show he was denied his constitutional and statutory rights to due process and a fair trial. So what they're saying, federal, constitutional, statutory, state. They say he's made a prima facie showing that he's entitled to relief. Like, here it is. Should be like in plain sight. Like, here it is. Showing that he's entitled to relief as to the claims raised in this amended petition. So it's what it sounds like. They're jumping on, and they jumped on and they amended his initial pro se, the one he did himself. So they jumped onto it and they amended it. So potentially, again, I'm not sure, before there was a decision on it, they came in and they supercharged it. They added to it. Okay. And we're not saying Scott's wasn't good, but obviously you get the Innocence Project and a bunch of attorneys and all these people working on it. They're going to probably beef it up, right? Okay, so they want the writ of habeas corpus granted and an order to show cause. Okay. And in order to show cause, ask for something to be done. Okay. People have to come and show cause as to whatever is going on. Okay. So the overview of the claims is a roadmap previewing the claims raised in this verified petition is set forth below to provide the court with the context necessary for understanding how the considerable, big word there, new evidence set forth herein proves petitioner's claim of innocence. Goodness gracious. The case against petitioner was entirely circumstantial. That's what they're alleging. At the close of the prosecution's case in chief, which included testimony from over 100 witnesses, the trial court summarized, and that's the prosecution, that's a lot of witnesses. 100. For the prosecution, that's a lot. The trial court summarized the evidence as follows. Quote, there is no evidence in this case how this crime was committed. There is no evidence in this case where it was committed. In closing, the prosecution conceded it also could not prove when the crime occurred. Now, I don't know when they say the trial court, if they're talking about the judge or the prosecution, because they're saying trial court. That they say in closing, the prosecution conceded. They said, we don't know when it happened and we don't know where it happened. Now, we don't know if the prosecution said that trial court is typically the judge, a judicial decision or agreement or whatever. So that's okay. So they're saying here that the prosecution's theory was that petitioner killed his wife on the night of December 23rd, 2002, or the following morning, and put her body into his truck and drove to his warehouse on the morning of December 24th, 2002, transferred her body to a fishing boat, and placed handmade cement weights and anchors around her limbs, put a cover on the boat to hide her body, and drove the boat on a trailer to the Berkeley Marina, put the boat into the water, and motored out into San Francisco Bay and dumped her body in the waters south of Brooks Island. And they're going to the transcript. I believe this is the transcript Bates number here. They continue. Law enforcement found no direct physical or forensic evidence supporting any part of the prosecution's theory or otherwise implicating petitioner, despite the execution of multiple search warrants and federal subpoenas, wiretaps that intercepted over 3,000 phone calls, GPS tracking devices on multiple vehicles, a poll camera surreptitiously mounted outside petitioner's home, steady surveillance by law enforcement over a period of months, and the forensic examination of several hundred items of physical evidence. There were no signs of foul play inside the Petersons' home, nor was any forensic evidence found inside the home, truck, boat, or warehouse. Nor were there any cadaver dog alerts at any of these locations. No cement, weights, or anchors were found in the shallow waters south of Brooks Island, despite extensive multi-jurisdictional search efforts that included the FBI, U.S. Coast Guard, and law enforcement from numerous other jurisdictions, specifically targeting those waters. Now, that's interesting because I'm assuming, I don't know, I just remember, I think that she floated up. She and the baby floated up. So if they were originally tied down with cement anchors and they came loose, she came loose, they should still be down there somewhere. Right? Okay. Further, they're saying, importantly, the medical examiner who performed the autopsies on Lacey and Connor after their remains were discovered testified that he was unable to determine a time, date, cause, or manner of death for either Lacey or Connor. So it wasn't drowning. It wasn't, okay. The prosecution's circumstantial case relied on the following evidence. Expert testimony of Gregory Devore, MD, who used a formula published in a 1984 article about gestational age assessment to calculate that Connor's date of death was on December 23rd, 2002. Okay, sounds like they were trying to guesstimate from his maturity, right? Like in the womb, his maturity stage. Kind of like, this is like not the same, but you can go and look at insects, right? From larvae to full bug and see the created timeline. So I'm guessing, sounds gross, but I'm guessing something along those lines. I'm not a scientist. They also had testimony by a hydrologist, Dr. Ralph Chang, who used the location where Connor's remains were recovered and wind patterns. He says patterns is in italics, which is there for a reason, I'm assuming. Rather than actual historic wind currents and tide data to opine, that's his opinion, that Connor's body, and by implication Lacey's body, originated in the waters south of Brooks Island, the location where the petitioner fished on December 24th. So, pattern sounds a little more generalized, right, than what the actual happened. I think that's what they're trying to say there. And also they're talking about the testimony by scent dog handler Eloise Anderson, who told the jury her trailing dog picked up Lacey's scent on the westernmost dock at the public boat launch at the Berkeley Marina on the morning of December 28th, 2002. They say the defense did not call any experts to challenge the testimony of Dr. Chang or Eloise Anderson. That's interesting. And the expert the defense called to refute Dr. Devore's opinion that Connor was killed on December 23rd, Dr. Charles March, did not have the requisite training and experience to effectively rebut Devore's opinion. So you're kind of saying that he sucked, I guess. The defense theory at trial was that Lacey was alive when petitioner left home the morning of December 24th, 2002, that she took the dog for a walk as she told petitioner she was planning to do, and that a number of eyewitnesses reported seeing Lacey walking the dog in the neighborhood and nearby park that morning after petitioner left home for the day. The defense argued that someone else killed Lacey and Connor and that there was no physical evidence linking petitioner to the crimes, nor was there any evidence showing when, where, and how the crimes occurred. So, eyewitness testimony, fallible. The defense argued that Lacey was abducted on December 24th, possibly by those involved in a burglary across the street that may have taken place that day, the Medina burglary, and that whoever abducted Lacey held her for a period of time before killing her and putting her body into the bay near petitioner's fishing location, which was widely publicized by the police and the media to shift blame to him. Okay, so it sounds like they're saying that these burglars, once she went missing, that they held her for whatever reason, and once she went missing, heard all the stuff about the police theories about Scott, and so they were like, hey, let's put her over here because we know he was over there. That's what they're saying, I think, okay? They're saying new scientific evidence that was unavailable at the time of trial in 2004 shows that the jury relied on false evidence by prosecution experts Devore and Chang, whose opinions have now been shown to be based on unsound science. Now, I don't know if that's in another case or this case or what. It says the new scientific evidence set forth herein shows that petitioner did not commit and could not have committed the crimes of conviction. Now, normally we get the Daubert and Fry challenges. Could be for I don't know where that's coming from, so we'd have to look for that. It says new evidence shows that the Medina burglary occurred on December 24th. Others were involved in the burglary, not just the two men who confessed. And a third burglar saw Lacey when they were committing the burglary. Todd Pierce, RZ, and others, who also may have been involved in the Medina burglary, were seen driving around in an orange van that was set on fire in the airport district around the time of Lacey's disappearance. Excuse me. And if Lacey was alive when the Medina burglary occurred, petitioner could not possibly have killed her or their son. Newly discovered evidence further shows that the defense was unable to present a complete third-party culpability defense at trial, pointing to someone else, because the prosecution intentionally destroyed and suppressed exculpatory evidence related to the Medina burglary investigation in bad faith, including critical exculpatory evidence that was destroyed just 2 weeks after petitioner was arraigned on capital murder charges. And that'll be kind of juicy there, because there's requirements under Brady and stuff that you have to keep stuff. Anything that's exculpatory, like you have to share it. We talked about you have to share it. You have to give everything to the defense, and you have to preserve stuff, right? And was the destruction, or whatever we're going to call it, whatever they're going to call it, accidental? Like, could it have been prevented? Was it intentional? And then how are they going to move forward with the case? Because due process, if something is gone, I mean, we have to look at two things. If something is gone that shows he's innocent, then how do you convict him? How do you move forward? And then, was it intentional? Okay. So that's kind of crazy.